His sister has threatened to kill me. My youngest daughter has been violent towards me. JJ has been violent towards the youngest child. I'm scared. I'm not just scared for me, I'm scared for my youngest child. My concerns stem from violence that has been, as you see in the evidence provided, acted towards me. It's been towards the younger sister.
Do for a living, but they generate a mountain of paperwork, a mountain of it, this much. I really don't need all that. And let me just begin with, even though I read it, Ms. Hernandez-Jackson, there is no such thing as a reply to a response, okay? That's not at all called for in the court rules, and I have to strike it. I did read it, but it's not a proper document to file because, quite frankly, as you could guess, if they allow your reply to his response, then he's going to file his reply to your response, and we're going to be at this thing forever. Plus, responses have to be filed at least 3 days before the hearing, and this one wasn't. But I did receive the original motion, and I did receive the response from Mr. Jackson. And before I turn to the parties, I'm going to tell you both this. You have a problem that has taken a long time to create. This child is 15, and when children reach a certain age, it's hard to force relationships upon people. Anytime there's a dispute between a child and a parent, the first line of defense for that parent is to blame it on the other parent and say they're alienating them. I don't know if that's going on or not. But I read some very disturbing things in here, things that don't quite make me happy. There have been numerous motions in 2022 on this case, and the last motion was October 25 of 2024. The last custody order was June 20th of 2019, and that was the judgment of divorce, and the parties were granted joint legal custody with plaintiff awarded physical custody. And now we are here because we have problems with this 15-year-old daughter. So I read your motion, Ms. Jackson. Anything you want to add to it before we hear from Mr. Jackson?
Of course. Thank you, Referee Winter, and thank you for the feedback. I appreciate it. I am here today as a mother who's deeply concerned about my teenage daughter. I do hear your concerns about relationships not being forced, but prior to the incident that happened August of 2024, my daughter and I did have a relationship, and I'm looking for reconciliation. My goal is peace, healing, and stability for her, for myself, and for her younger sister. And my concerns stem from violence that has been, as you see in the evidence provided, acted towards me. It's been towards the younger sister. And unfortunately, I had to make a really hard choice, Your Honor. A choice where if
These are legal custody issues, he reminds them, and they cannot be ignored.
Eldest daughter's actions, how they would impact the youngest child, who I am solely responsible as her father, left the picture when she was 4 months old. So I am the sole provider in that situation. I want the court to know that I have not contested paying for my daughter's needs, our daughter's needs. I continue to pay child support. I cover the phone bill for Mr. Jackson's eldest daughter. I was married to him for a really long time, so I feel like it's the right thing to do. And she's had a lot of behavioral issues with Mr. Jackson in the house and just et cetera. She ended up having to go to military school. So that's the one thing I could commit to while I'm in an active Chapter 13 bankruptcy. And I even pay the YMCA membership for him and the children so that they have that. But despite paying Mr. Jackson, ultimately, he has placed limits, whether we get therapy, he has used the words against me, his family has, his sister has threatened to kill me. My youngest daughter came home in August of 2025. She saw her eldest sister and she told me, hey, Jayla hates you. I mean, excuse me, I'm so sorry. JJ hates you. And mommy, her aunt wants to kill you. And JJ said she's going to take you away from me one day. I am just asking, Your Honor, for a guardian ad litem. I've sat with legal aid too over the past couple months to work on this because transparently, Your Honor, it took me a while. I do not live in Grand Rapids. I had to turn over my car because I'm in an active Chapter 13, and now I'm in process of getting a new vehicle. The trustee has approved it due to my youngest daughter being in a school district that requires me to have a vehicle. And I'm asking for friend of court review that includes therapy history, the domestic violence context, and academics, and to allow me to obtain the 5 years of records to provide that to the FOC review, order neutral court-approved reunification therapy with no unilateral provider charges, and provide support such as high conflict parenting education through FOC resources, and enforce parenting time that is consistent with our original agreement, but after reunification therapy and things are safe for my youngest daughter and I, because that is my biggest concern. JJ has been violent towards me. JJ has been violent towards the youngest child. JJ has been, unfortunately, I believe, coached and trained to say the things that she said to her grandmother, who is 68 years old. JJ was telling my mother and my child that her aunt, Casey, threatened to kill me. And I am just extremely concerned. And I have tried my best. But also, I was very sick. I had a emergency surgery in the middle of March that also delayed to this process. And I had a lot of complications with that surgery. I ended up losing an organ. So I just got off FMLA recently and I'm still, adjusting to like a new normal with a missing organ. So I'm just asking for the court's help. That's all I'm asking. My daughter and I talked actually yesterday because I told her I'm buying this car. Hey, this is something I want to give to you next year when you're able to drive yourself to school. She was like, I like it. It's great. But there are some deep rooted issues that we need to talk through and address before I can have her in my house. I'm scared. And I know I've communicated with you back in the hearing in February. And I'm not just scared for me, I'm scared for my youngest child. When you have an eldest child.
Okay, I got it.
Yeah.
Hernandez Jackson, you're starting to repeat yourself.
Okay, sorry.
That's all right. We don't appear in court all the time. I read those things that you requested, and quite frankly, those are going to be cost prohibitive for you. A guardian ad litem costs $5,000 to start, and usually I will split that if I feel that both parents are not looking out for the best interests of their child. Right now, I don't have that yet, but it's a tool in my toolbox. Mr. Jackson, what's going on?
Yeah. Good morning, Your Honor. I'll say I take great offense to how the plaintiff is characterizing my relationship with our daughter and our daughter overall. She does deal with depression and anxiety, yet my daughter has had lead roles and plays as a freshman last year. She's on the softball team. She carries a 3.0 grade point average. despite of the challenges that she's had with her mom. She has weekly therapy. We're up to date on all medical and everything. We're up to date to. The plaintiff has access
The judge delivers his ruling with steady authority. Physical custody remains unchanged.
to school records, medical records, everything. She's in the past set appointments, everything that she stated within her motion, she has access to. As far as any violence or whatever, I don't communicate with Miss Jackson unless it's about our daughter. We have not had interactions, personal interactions in years. These things that she's characterizing is false, really. The notion that our daughter told her daughter about my sister is just false. It's just false. And in the past and in my attachment, I've shown Miss Jackson has asked our daughter not to speak to her. She's asked her not to reach out to her family. She's told a 15-year-old, please don't contact me or my family. How do you do that to your daughter? That's an issue between Miss Jackson and our now 15-year-old daughter. In the past, I have tried to help heal this relationship. Within the past year, I've driven down to Detroit 2 times for our daughter to see her sister, who is not my child. That's not my child. But I want to foster a relationship between her and her sister. Me and Miss Jackson, after the October 25 hearing, had an agreement that we would meet monthly in Lansing. The first meeting Miss Jackson canceled because of transportation, and then got upset with me because I said I would not make a weekly trip to Ann Arbor to spend 8 hours stranded, basically, while her and our child spend time together. On top of it, I have to be around if it's just them because Miss Jackson, in the environment she's created, is hostile for our daughter. And I have to be around in case I need to come pick her up or grab her. Your Honor, honestly, this relationship has nothing to do with me. Our daughter is 15, intelligent, and bright, and has the tools to help start a healthy relationship. Miss Jackson should seek a relationship with our daughter. This has nothing to do with me.
Well, one of the things that concerned me was there was an allegation that you, even though both parties have legal custody, that you unilaterally placed the child in therapy, that there's been some medical neglect, that there was a drug overdose that she didn't find out about. Those are all legal custody issues that need to be discussed between you and Ms. Hernandez Jackson before you do those things. Do you both understand that?
Yes, Your Honor.
Your Honor, she had the opportunity to help with that. I used the app that she provided me to seek counsel for Miss Jackson, and then I provided her all the information once me and our daughter settled on a therapist.
Okay, here's what I'm going to do. This what I try and tell people is at some point in time, this moves from a legal issue to a mental health issue. And I think you're knocking right on that door because 15-year-old kids, you can't just grab them by the nape of the neck and throw them in the car and say, you're coming with me. And it becomes difficult. Even though they're minors, it becomes very difficult. But I don't like the unilateral nature of what I'm reading on some of these things. So what I'm going to do is I'm not going to touch physical custody, but I am going to refer legal custody to the front of the court for an investigation and recommendation and see if joint legal custody is still warranted. Maybe it should only be given to one of you who would then make all the decisions relative to school, doctor's appointments, therapists, that type of thing. I don't know if that's the case, but I have to do a deeper dive on that. I can't decide that on a Friday morning. So the fees for that are $300. I generally split it if both parties are working. Are you working, Ms. Hernandez-Jackson?
I work, but I'm in an active Chapter 13, and I am bound to a budget. I am paying the child support. I am paying the motion for the extra medical care, but anything else, it would stress me to a point where I have a small child that I have sole custody of and take care of on my own.
Are you currently working, Mr. Jackson?
Yes, I work.
Okay. I think what I'm going to do is this. I'm going to prepare an order of reference. I will waive the fees for this this Hernandez Jackson, so neither party has to pay this.
Thank you.
You should be hearing from the front of the court shortly, and once they complete their deeper dive in this, they can make a recommendation to me as to how we proceed. I think that's the only fair thing to do at this point. So
I
it's
agree.
nice seeing both of you. I wish your 15-year-old the best. This is tough business, especially with a 15-year-old. So we'll see if maybe the front of the court can give us some guidance on.
The judge waives fees, sparing both parents the burden. For now, the case moves forward under court investigation. As the gavel of justice rests, his words linger. This is tough business, especially with a 15-year-old. The future remains uncertain, but one truth is clear. The court will not turn away.